protocols. So as always, please note that only ACUS members, which includes government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the Judicial Review Committee and designated alternates, have full speaking privileges. To avoid background noise, please keep your microphone on mute when you're not speaking and either use the hand raise function in Zoom or add a comment in the chat box if you'd like to speak. And then I will call on you and you can unmute yourself and then remute yourself once you're done speaking. I would also ask, although it looks like most everyone's doing it today, that ACUS members and alternates use the webcam or keep their webcams on to facilitate today's conversation. With respect to any attendees other than ACUS members and alternates, participation requires unanimous consent of the committee members. Time permitting, we will consider calling on such attendees at appropriate points in today's meeting and will presume that committee members consent unless someone raises an objection. If you are not an ACUS member, but you would still like to speak, please indicate in the chat function, or you can also use the Zoom hand raise function and wait until I call on you before speaking. For all participants, please use the chat feature only to indicate that you'd like to speak or for committee members and alternates to vote when asked to do so. Please don't hold sidebar discussions or put substantive comments into the chat box. Finally, only members of the Judicial Review Committee have a vote. Please do not vote unless you are a member of the committee. If you're unsure of whether you're a member, we have a list of committee members and can check that for you. So with that out of the way, we're going to turn to our discussion of the draft recommendation, which we're going to pull up on the screen.
So Kazia, it's Don Elliott and I'm here. I'm sorry, I was having computer problems, so I switched to a different computer.
All good. Thank you so much.
Okay, great. Thanks, Kaja. For today, let's just follow the same course that we've been following for the past 3 meetings. And if we could just start with the recommendation text. And these have been pretty thoroughly debated at this point, but we'll just go through them. So we'll open the floor to any further discussion on recommendation 1. If you'd like to speak on recommendation 1, please use the Zoom hand raise function or note as much in the chat. Okay, then we'll move on to recommendation 2. Tom, did you want to provide a little bit more context on the potential interaction between the pending proposal and this recommendation?
Sure. I just want to make sure that the committee is aware that the rules committees of the Judicial Conference have received 2 proposals to amend the rules of civil procedure to address case assignment. And the proposals advocate adopting a rule that would require random case assignment for certain kinds of civil cases, not limited as this recommendation is to judicial review of agency rules or policies, but limited, but addressed more generally to certain categories of civil cases. And that's currently under consideration by the rules committees. So we don't yet know whether there will be a proposed rule amendment on this topic. There's a good deal of work still to be done. We're at a very early stage of considering these proposals. But I wanted to make sure that ACUS is aware of it and the fact that there may be another proposal to create a rule in this area. We're not advocating at this time any different course for ACUS or this committee, but just wanted to be sure that the context was there.
Thanks, Tom. Mila?
I wonder if Tom could say a little bit more about the categories of cases other than challenges to rules that are covered by these proposed amendments.
Sure. So we've received a couple of suggestions, and those are documented on our. So Joe Mead has put up the DOJ letter, which is one of the suggestions. We've also received a suggestion from a professor at the University of Pennsylvania and another organization jointly. And there are various approaches to this. They all sort of generally revolve around similar considerations that also informed the Judicial Conference policy that was discussed at the last meeting. That is to say, categories of cases, and again, this is all at a very early stage, so we don't know exactly what this might look like if the Rules Committees move forward with this, but categories of cases that affect more than just the parties before the court, or that do not require some kind of local community focus for the case, right, and a judge in the community. So again, the suggestions differ in the specifics of those approaches, but they all have in common those kinds of same concerns that I think also inform this committee's discussions.
Thank you, Tom. Ron?
And are these only relating to assignments within a district or more broadly?
Yes, that's right. This is only assignments within a district. The proposals that we've received in the Rules Committees do not address the broader question that this committee has considered but is not currently reflected in the draft recommendation concerning venue more generally across districts, or forum shopping more generally across districts.
Thanks, Tom. Are there other comments either on this same topic of the Rules Committee or other comments on recommendation 2? Brad?
Find the unmute. So I think we would renew our proposed amendment to the not to the recommendation, but to the preamble as to the Judicial Conference recommendation. I don't know if you want to do that separately or you want to focus on the recommendation now, but just like we wanted to do that.
Yeah, so let's, right now it's mentioned in the preamble, and so I think we can have I'm sure there'll be some discussion about it there. Okay, if there are no more comments on recommendation 2, we can move to recommendation 3. Okay, and seeing no hands, then I think we can move to the start of the preamble and work our way through. So what we'll do is, unless there are comments, we'll go paragraph by paragraph, and then for paragraphs where there are comments, we can go in a more granular level. So are there comments on paragraph 1? Okay, then let's move on to paragraph 2. Is there a way to fit it all on one page? There we go. Thank you. Just gonna give folks a chance to reread it to refresh their memory if needed. All right, then we'll proceed down to the next paragraph. Comments on paragraph 3. Okay, and the next paragraph, lines 27 through 32, we have a question from the committee staff, which is whether the committee wants to be more specific about how this recommendation builds on the prior recommendation. I will note for the committee that in the next section, determining the court in which to seek review, there is some explanation of the relationship between the two, but perhaps not for recommendations, for the other recommendations. Do folks in the committee have views on the question from the staff? Okay, I will take that as either a sign that we're all agnostic or a lack of a desire to add more detail. Then I think we can proceed to the final sentence, lines 31 to 32, where Alan has proposed an edit, which I think we'll take unless there are any comments on it. Okay, perfect. So the next paragraph, the first portion of the explanation. Oh, sorry. Ron, did you want to?
For the next paragraph,
Okay, perfect. Ron, go ahead.
lines 33 to 34. I wonder whether what you meant to write was, by default, parties may seek review in a district court according to the usual rules governing civil actions. Otherwise, it sounds circular.
So you would take out the rest of that sentence, judicial.
Yeah.
recommendations. Okay,
Correct.
thank you.
Thanks. Allison, do you have something on this proposed edit?
Yeah, I just wanted to suggest maybe we get rid of by default, because default actually has a specific meaning for law and it's sort of not default. And also, since it says like according to the usual rules, that makes what we colloquially mean as by default unnecessary.
Okay, thanks, Allison. Tom?
Yeah, I'm not sure if this is right, but one question I had is whether usual rules actually refers to principally statutes, since venue is largely governed by statute, and obviously the rules of procedure play some role, but not the only role. So wonder if there's an edit there that might be appropriate to be sufficiently broad to encompass statutes as well.
Tom, what, just thinking of proposed language to put on the table, would statutes and rules or rules and statutes work?
Yeah, I don't have a strong feeling or specific preference, and if others don't think this is a significant concern, if the colloquial use of rules to refer to statutes is the norm, I don't object to that. Just wanted to flag the question.
Okay, thanks, Tom. Alan, I saw you next.
I think that we need to add something back in about governing civil actions against or involving administrative agencies, because that's not the general rule, and there are some specific rules about where cases can be brought, the mandamus statute, for example. But I don't want to go into it. It doesn't matter. I think that we were right to make the change that was made before, but I think we need to put a little something. Civil actions,
Okay.
I would say against administrative agencies, or against administrative agencies.
Okay, thank you, Alan. Don?
As I understand it, the law on this is that absent a statute placing review into the Court of Appeals, parties may seek review in a district court. But I think the way we've written the first sentence is now too broad. So I would propose that rather than by default, we say absent a statute, and we could say or court decision. Otherwise, parties may seek review in a district court. But my understanding is that the Supreme Court has been pretty firm that even if there are policy reasons to go into the Court of Appeals, absent some statutory language, you don't go into the Court of Appeals, you go into the district court. But I could stand corrected by others, but I don't think we want to make an absolute statement that you can always go to the district court, which is how I read the current language.
Okay, thanks, Ron. Mila?
I think responding to what was just said, perhaps we could say parties may generally seek review in a district court according to the usual provisions governing civil actions against administrative agencies. So that way it's not unqualified, and we avoid using the phrase rules and statutes when some of those statutes may in fact tell you to go to an appellate court.
Thanks, Mila. Ron, does that satisfy the concern that you raised earlier?
I was just going to make a small edit to the Tom Byron edit by saying statutes or rules that usually govern. That
Okay,
might
but,
get
I just wanted to
become
ask-
relative to all the other things we're doing.
I wanted to ask if the generally edit accomplished the same as your absent a statute or other court decision otherwise, in which case I might suggest that we proceed with the simpler one.
Well, in the first place, that was my suggestion.
Oh, sorry.
Don
Thank you,
Elliott,
John.
rather than Ron Levin.
Right.
Yes, thank you, John.
Yeah, but the question is for Don about which you
Yes.
prefer.
That's what I'm trying to do.
I-
Don, can you respond?
I like absent a statute or court decision otherwise better than generally, which I think is vague. And I don't think that we are in the recommendation endorsing the notion that parties can generally seek review in a district court. We have some specific exceptions. So I think absent a statute or court decision otherwise is better, but I don't feel strongly about it.
You're muted.
Thanks. Ron, you had another edit that you wanted to put on the table to this sentence?
It's going to just have usual modified govern provisions that usually govern civil actions.
Okay.
Although statutes and rules might be more illuminating. I'm not sure
Okay.
if Mila had a reason not to do that.
Mila, do you want to respond?
Yeah, I just didn't want there to be any confusion at all between the federal rules of civil procedure and rules promulgated by agencies. And so I just wanted to avoid that entirely by using provisions to encompass both statutes and rules.
Okay.
Do rules by agencies govern federal court jurisdiction?
No, certainly not jurisdiction. But just because we are talking about rules governing civil actions, I was worried that there might be confusion that could arise, because here, just that phrasing, rules governing civil action, just usually connotes the federal rules of civil procedure.
Thanks, Mila. Alan, do you want to chime in?
Yes, actually, I think we can cut out court decision otherwise, because the court decisions have to interpret statutes. Only statutes could provide jurisdiction in the Court of Appeals. And I think we can also, according to, and I would take out rules also, and rules provisions also, because jurisdiction is entirely statutory, and federal rules of civil procedure or appellate procedure can't change that around. So I would say, absent a statute, parties may seek review in the district court let's see, for civil actions against administrative agencies, or involving civil actions against administrative agencies. So absent a statute, comma, parties may seek review in a district court in civil actions against administrative agencies. So as a benefit of even being shorter.
Okay. Thank you. So, Don?
I'd be fine with that. Taking out or court decision. Otherwise, I agree that it is a statute. So absent a statute I'm fine with it. Another alternative would be according to the usual statutes and rules of civil and appellate procedure to avoid Mala's concern, but I don't feel strongly about it. I'm happy with Alan's shorter version provisions that usually govern.
Okay, thanks. Then I think we'll just keep the two options on the table rather than adding a third if you don't feel strongly, John. Abby?
That's fine.
There we go.
I can't get myself unmuted, sorry. I just think, Alan, don't you mean absent a statute stating otherwise? You don't just mean absent a statute, a word is just dropped, just a friendly amendment.
Sure,
Absent a
Yeah.
statute indicating otherwise or whatever, so just.
providing otherwise. Providing otherwise. Okay. Oops. Hold it. I muted myself.
Okay, great. Mila, can I ask, it seems like generally might be if we keep in absent a statute providing otherwise, then generally might not be necessary. Does that, I want to ask you because that was your proposal.
Yeah, I
Okay.
think mine was superseded, so that's fine.
Okay, great. Then I think the only debate left on the table is statutes and rules versus the single word provisions. Which I guess we can take a vote on. So if there are folks who prefer statutes and rules, we'll have them, well, that'll be the first option to vote for. Provisions will be the second, and we'll just take that. Alan?
I don't think we even, I mean, my proposal was to eliminate statutes, rules, and provisions entirely. Parties may seek review in a district court in civil actions against administrative agencies. And so we don't have to, if you adopt my proposal, we can strike out, we don't have to debate between those two options.
Okay, so why don't we do this? Is there anybody who objects to Alan's proposal?
I have
Abby?
one quick question, Alan, just to
Yeah.
clarify the question. I'm just thinking about the no judicial review provisions, those never occur in rules. They're always statutory in admin.
My understanding is yes.
Okay, I'm just trying to, thinking through my mind, I'm cycling through Medicare, I'm just thinking through the statutes that I know. Okay, that's my only clarifying question.
Okay, hearing no discussion on Alan's, Ron?
Alan, I wonder if you want to say, absent a statute, parties may seek review of administrative actions in a district court, according to statutes and rules that generally provide such. Now I've lost it, but that's where I'm going. Governing such action.
And
I don't
can I
think-
ask
I
Ron,
think
is
you-
that a, I think we were trying to get to consensus, so obviously
Well, I don't know if Alan thinks it's friendly.
It's, I don't mind, you've moved, all you've done is move the end up to the middle. And I'm okay with that. I think that's fine. But then we don't need to say anything else because governing such actions. Parties may
Yeah.
seek judicial review in a district court, period.
Okay, I'll just note there is a distinction, although we've somehow circled back, I think, to something like the original language. There's a distinction between administrative actions and civil actions against administrative agencies, I think, or at least it seemed to me like the earlier suggestions were identifying one. Tom?
Yeah, I just was questioning administrative actions. I wonder, Ron, if you meant administrative actions, administrative agency actions, or
It is what I
agency
meant, yes.
actions? Yeah.
That is what I meant. But Alan is making it, I mean, we're now hearing a circularity point, which, and I'm willing to withdraw it because I don't feel strongly.
Okay, so I now read the text to be absent a statute absent a statute providing otherwise, parties may seek review in a district court in civil actions against administrative agencies. So I think we will adopt that unless somebody objects. Tom?
I don't object. I just wonder whether we need to say seek review of rules, since that's the focus, I think, of this section, but maybe I'm mistaken.
I think that's a good idea. Then if
Okay,
we said
do we
that,
think we could, sorry, before we get further comments, do we think we could clean up the text of this sentence so we all see clearly what the sentence says? Thank you. Are there comments on the sentence as it stands now?
Yeah.
Alan?
I think we might add seek judicial review of agency rules, add judicial review and then agency rules in the district court. And then we don't need in civil actions against administrative agencies then.
Okay. We'll do the same thing. Unless there are objections, we'll move on to we'll consider that the sentence and move on to lines 34 through 35. Okay. Um, 35 through 36. Okay, in the next sentence, we have a comment from Alan, which is explained, but Alan, do you want to say anything else about the proposed amendment?
I just think all I want to say is we're going to have proceedings of some kind, whether it's a motion or whatever it is. And that was, I think, inaccurate as written. Doesn't change anything. And a district court does not need to create a record, I think is what the point that you're trying to make.
Okay, great. So we'll take that amendment unless there are further amendments to it. Matt?
I just want to raise a question maybe for Alan or maybe Ron or anyone else. John Siegel at the last meeting, I'm kind of speaking for John, I suppose. I don't think he's on the line. He objected to the suggestion that a district court creates a record. And he was referring to creating an administrative record. It's just really a question for the committee whether create a record is the right phrase in this particular context.
Would it avoid that concern to say district court review is less necessary? I'm sure there'll be debate about that phrase when an agency has already compiled a record that is adequate, et cetera, et cetera.
I don't know.
Okay, well, we'll take the conveyed comment. And Steph, did you want to speak?
I was gonna suggest develop in lieu of create, because I think
Okay,
what the judge is doing is they're building upon work the agency has already done, perhaps asking the agency to pull it together. Very rarely, there's fact finding, but all of that would be development.
thanks,
Yeah,
Steph. So
I
Matt, I
think-
hate to ask you to play telephone, but do you think that would?
Yeah, I
address it?
think that gets closer to John Siegel's concern. I mean, I don't know what the quite phrasing is. I mean, it's pretty rare that a court should generally not be holding an evidentiary hearing. I probably needn't say that. It's facilitating the record, like Department of Commerce versus New York, or whatever the order of the parties' names was. The district court it compelled the agency to complete the record. I think that was the phrase that was used. But I think John's concern was the suggestion that the court is creating an administrative record.
Okay, thank you, Matt. Alan, I saw you next.
I thought your suggestion was fine. For one, a district court is less necessary, or proceedings in a district court are less necessary when the agency is already, in other words, we don't need to put in a phrase instead of that. Because it was duplicative in any event. Yeah, and you strike district court above, yeah. And that's just a statement of fact. We don't create anything or do anything. I think that
Okay.
Jonathan will be okay with that, don't you, Matt?
Thank you, Alan.
I think so, yes.
Okay, great. So I saw Don next.
I was going to suggest, for clarification purposes, district court proceedings to supplement the administrative record are less necessary. And that, I think, clarifies that there is already an administrative record.
Okay, Tom?
Yeah, I may have misunderstood Alan's original suggestion, but I thought it was helpful in part because there is a difference between the record on appeal, which the district court does create in a case that begins in district court, on the one hand, and on the other hand, the administrative record that the agency creates. But if I'm mistaken, and that wasn't your point, Alan, then I think where we're landing or heading is probably fine, but I just had that question for Alan.
And can I ask, Tom, would it make things clearer from your perspective if we said where when an agency has already compiled an administrative record?
Yeah, I think that is very helpful. Yes.
And then, okay, great. So I'm going to go, just because I took time to be asking a question of Alan, to Alan next.
I was going to say that I don't think we need what Don suggested in there. I think, I don't know whether it's supplementing the administrative record or we don't need to do anything. Just, we're making a statement of fact. District court proceedings are less necessary when the agency's already compiled an administrative record. There are no disputed issues of fact, and further appeal is likely. This is a preamble we're writing here too, remember.
Okay. Thanks, Alan. Matt, is your hand back up? I couldn't tell. Okay, great. Don?
No, it's not, sorry.
Sorry, Don's hand just went down too. Are there so we still seem to have two options on the table. Should it say a district court does not need to develop a record when an agency has, or should it say district court proceedings are less necessary when an agency has? Do any folks have further comments on the choice between those two? Alan, are you raising your hand?
Yes, I withdrew the no need to develop the record suggestion, so that's off the table.
Okay, great.
Sorry, I wasn't clear about that.
No worries. Don?
I'm concerned a little bit about the language about no disputed issues of fact. There are often disputed issues of fact, and I don't think we want to apply that there ought to be reconsideration of disputed issues of fact that were discussed in the administrative record just because there continue to be disputed issues of fact, which was why I had suggested language about supplementing the administrative record. But I'm troubled by suggesting that whenever there are disputed issues of fact, or that there has to be an absence of disputed issues of fact, so I would just propose to strike there are no disputed issues of fact, because there are often disputed issues of fact. And that's one of the issues that Court of Appeals sometimes has to resolve. There are disputed issues of fact.
Okay, so we'll put the proposed deletion on the table. I will say my understanding, and I think this is based on language from the prior recommendation, is that this is sort of an and perhaps there's a way to convey it more clearly, but it's reflecting the comparative lack of factual disputes in between a regular district court case and a direct review case, in which, you know, there might be disputes of fact about, for example, standing, but they're limited in comparison to the district court proceedings. But Alan, did you have comments on this one?
Yes, I didn't mute myself. First, I think we probably ought to add the word material facts if we're going to come in there, because that's the language of Rule 56. And that, but I think the argument is that there are no disputed issues of material facts that should be resolved by the district court. That's the question. But the point is, there may be the disputed issues of fact, but those have to be resolved based on the administrative record.
Can I ask, Alan, when you say that should be resolved by the district court, I just want to make sure I'm captured. It is another way to put that. You're trying to get at the idea that there's not a disputed issue of fact that the district court is sort of comparatively better suited to address. Is that right?
No, I think that not even comparatively. I think it's just that they're not entitled to address them. That is, if the administrative record says A, some evidence says A, and part of it says non-A, that's not the job of the district court to decide unless they're deciding the merits. But I guess, I mean, maybe it's
would it be
issues.
okay? Sorry, I'm just trying to. I'm trying to avoid ambiguity, but would it be accurate from your perspective to say material fact for resolution by the district court? Or would you prefer the prior language?
I think I should hear from Don, because he has some thoughts about this. I
Sure,
think
Allison had her hand up next, so we're gonna go to her then.
Sorry.
That's okay.
I wanted to speak against Alan's addition, because to me, that sounds like we're saying for the district court as opposed to the Court of Appeals. And actually, the way these are resolved in the district court, they're resolved on summary judgment, which by definition means there are no genuine disputes of material fact. So, and that is why, because everyone agrees that these are summary judgment cases, and the court is not actually sitting as a fact finder. That's why I thought that we thought it was appropriate for the Court of Appeals, because actually there are, other than maybe standing, there are, the court is not deciding factual issues, even if it's looking at the administrative record. It's not, it's that we're sort of, it's not, the standard review is not like a de novo review of the agency's fact finding. So anyway, so I think maybe if we were going to say anything, I think we need to get rid of by the district court, which suggests we think that the Court of Appeals is going to sit as a fact finder. But maybe the easiest thing to do would be to take Don's original suggestion instead of wordsmithing it and just get rid of it, unless people think it's sort of necessary to explain our reasoning. I think having the two reasons, the fixed factual record that is the administrative record, and that the appeal is likely, maybe is enough to justify it. Otherwise, maybe we can just, well, no, but then I don't think Don would agree that it's something about the lack of fact finding.
Would Allison, would it, if the second clause said, so it'll say where an agency has already compiled an administrative record that is adequate for judicial review, comma, judicial review is based on that administrative record, comma, and further appeal is likely. Would that capture what you're trying to get at? And then we would delete, yeah, it's on my version.
But I think that would, that sounds fine to me. I don't know if people still want to say something about lack of resolving factual issues. I don't think we need to say whether that's happening or not. But I think your suggestion is fine with me, that people who wanted to put in the part that Don originally suggested deleting might not be happy with it, but I think it works for me.
Okay, Alan?
I had an
Alan,
alternative
oh, there we
suggestion.
go.
But yours is, the alternative suggestion I had, just so it's on, there are no disputed issues of material fact that have to be decided outside the administrative record, but that I think yours is a shorter, better way to say it.
Yeah, I think that's right. And I also think the standing, because standing is sometimes disputed, I'm not sure that that statement is always true, but yeah. Okay, so this is the language on the table. Are there other comments on this sentence? Okay, Ron?
I'm not sure I follow what is meant by the phrase judicial review is based on the administrative record. Or rather, I'm not sure why it's necessary. I would have thought that was implicit in what is being said otherwise. What situations would that not address? Because
Yeah, thanks,
so
Ron.
you-
So what I was trying to do is I
something
thought Alan captured it. I just want to to explain. I think Allison captured what this sentence or clause was trying to get at by saying the Court of Appeals is not, or the reviewing court in general is not sitting as a fact finder as to the underlying claim. And so I had attempted to come up with some language to capture that, but I think if folks would prefer, as Allison also put on the table, to just delete the clause, that's an option we can go with.
I think I'd delete it.
Okay, so why don't we do this? Let's get all the way, let's do the rest of the sentence all the way up to that clause, just clean up the sentence. So lines 36 through 38. And then I didn't get Tom, yeah?
Oh, I think you meant to delete a district court in line 36.
Great. Steph?
My point is on lines 40 to 42. So it's this.
Steph, I can't.
Sorry, Steph. Yeah, I couldn't hear you.
My point is on lines 40
Okay,
to
yeah, I think we need
42.
to, yeah, we need to wrap the sentence up first before we get there. So,
Okay.
So I take there to be consensus on everything up to the judicial review is based on the administrative record phrase. So I think what we'll just do is quickly say, if you want, we'll do a very, very quick vote. If you want to keep the clause as is, that'll be option 1. If you want to delete it entirely, that'll be option 2. So if you'd like to keep the phrase judicial review is based on that administrative record in, please raise your hand to vote. Okay, and if you would, sorry. Okay, I saw 3. If you would like to delete the phrase judicial review is based on that administrative record, please vote. Okay, I'm gonna vote to keep it in because we need to break the tie.
It's not a tie because Don raised his physical hand.
Okay, that's not one of the voting procedures, but Don, which option did you vote for?
I voted for deleting it and it just didn't pick up my hand raised, but it is now.
Okay,
So it was 4-3.
okay, then I'm happy to go with the consensus of the committee to delete it. Okay, and then we'll move, Abby, is your hand up to vote or to speak? Okay, I'm gonna assume that we can move on to now it's line 39 through 41. Steph, I know you had wanted to speak earlier.
Yes, on this sentence, I think that the sentence doesn't explain the why this is the case. And I would recommend just a supporting citation. I'm not sure if there's an appropriate place in the consultant's report, or if we could cite to the statute implementing the conference's recommendation on the race to the courthouse. But I think there should be something there.
Okay. I think we can defer that to the committee staff to find an appropriate citation to support that statement. Okay, seeing no other hands, we can go, Alan.
No, I was just going to go to the next one.
Yeah, perfect. Next sentence, Alan.
This is one of the major debating points of all times. As read by a court of appeals, it sounded to me like as though it was a particular court of appeals, like the DC Circuit. And I just wanted to make it clear that it's going to the courts of appeals under the usual rules for going to the courts of appeals.
Okay, thank you, Alan. Are there other comments on Alan's proposed amendment? And if not, we'll take it as accepted. Okay, great. The final sentence. Alan, I'm assuming your hand is still up from earlier. Is that right? Okay,
Yes.
great. So then we'll go to the next paragraph, lines 44 through 51. Okay, we'll keep going. To the, sorry, Kaja?
I just wanted to raise the point that in line 45, we say by a court of appeals. Alan, do you want that also changed to be in the courts of appeals?
Alan?
No,
Okay,
no.
just wanted to double check. Thank you.
Thank you for asking.
Don? Sorry, Don, you might be on mute.
Sorry, I just wondered if we really wanted the word similar in line 48. If there's another statute that provides for review after public notice and comment, I don't think we want to have arguments about to what extent it's similar to 553, and just say as provided in 553 or another statute, but I don't feel strongly about it.
Okay, thank you, Don. Abby?
So I just want to ask if the intention of line 46 is to narrow the generally affirms earlier recommendation language. It's a little ambiguous. So the way it reads now, it generally affirms the idea that there should be direct review, but the conference now believes the principle should apply to notice and comment rules. So is the intention of that sentence to say maybe not all the rules, but notice and comment rules especially, because it's not entirely clear.
Yeah, so the intention is to convey that this is broader.
No.
So we can think about how to do that clearly.
No, the intention is that it's narrower, right? That notice and comment is the critical factor.
Well, perhaps we can get the,
That's unclear, so it's, so the reader, it's not entirely clear what the intention is of those two sentences working together.
Don?
I agree with Abby. I'm read it differently. Maybe we could say now the conference now take out the word now. The conference believes that this principle is particularly important.
Yeah,
for all rules.
That's what I thought it meant, but that's what the intention is. That'd be helpful.
That I think is the intention. We're not backing off from the earlier recommendations or narrowing them. We're just saying it's particularly important for these. That's my understanding anyway.
Okay, thank you, Don, for putting that on the table. Are there other comments on the paragraph as with, as amended? Steph?
I just wonder if we could strike the all, because I agree it's particularly important for rules promulgated after notice and comment procedures, but we do use the word ordinarily in the recommendations. I think this actually goes a bit further than what we recommend.
Thanks, Steph. Are there other comments? Okay, hearing no objections to the proposed amendments, we'll take them. Why don't we start with Alan, if you wanted to give any additional comments on your proposed amendment?
Sure. The way it's written now is the federal statute doesn't dictate division must be brought. And we're only talking about federal agency rules. And we need to qualify it. That's the only point I wanted to make. Because the venue statute does apply in other kinds of cases, and some venue statutes tell you where they have to be given and so forth and so on. But this is only federal agency rules being challenged.
Thank you, Alan. Are there other comments on what we'll call lines 52 through 55? Andy?
Yeah, small thing. I think we need an A after in which on line 53. Yeah, right there.
Would it also work to say does not dictate which particular division of a district court cases must be brought in when a rule issued by a federal agency is challenged?
I think
Does that
this,
address your concern, Andy?
I think it's grammatically correct as written.
Yeah, that works for me, but I see Ron has his hand up.
Well, I do think, sorry, you're gonna recognize me.
Yes.
I do think it is hard to read either way, because of the way the sentence is constructed does not dictate in which. The meaning kind of gets lost. So I thought you could rephrase it to say, the federal venue statute does not specify that district court cases must be brought in any particular division. Thus, it allows the litigant to choose.
Ron, did you also intend to delete the language about when specifying?
That's why the district court cases must be brought in a particular division. Thus, yeah. Thus, it allows the litigant to choose. That's what I meant to say. Could be
Okay,
wrong.
so
That was
you
my-
are suggesting deleting the language when a rule issued by a federal agency is challenged, or you're not?
Hmm.
Okay.
I
Abby?
guess I'm leaving it in.
Yes.
Okay, Abby?
Litigant can choose, but the court can move it under 1404, so choose a division in which they file is really probably more technically accurate.
So choose the division in which to file, is that?
Venue transfer can be, venue can be moved in the interest of justice, and so
Right, sorry, I'm just trying to put an edit on the table, so allowing a litigant to choose the division in which to file.
Yeah, something like that.
Oh, I see, okay.
Okay, are there other comments on the sentence running from 53 to 56?
Um,
Alan, are you raising your hand?
yes.
Okay, great.
Do we need specify? Does not dictate, does not specify. Do we need that district court cases must be, that cases must be brought in a particular division? That is, do we need, we don't think we need that, doesn't specify that district court cases. Obviously, we're dealing with district court cases because that's the only place that has districts and division. Does not specify that cases must be brought in a particular division when a rule issued by a federal agency is challenged, comma, allowing a district litigant to choose the division in which to file.
So I could go change specify to provide,
Okay with me?
but I think allowing makes the sentence too long, so I would cut it off in there and say thus a litigant
Yeah.
is able to choose.
Okay, let's make sure before we talk about dividing the sentence, let's make sure we're I don't hear any objections to the language as written. There's a separate question of whether to divide this into two sentences, but giving folks an opportunity to make any additional comments about the content of the sentence. Okay, then Ron, you'd prefer to break it up?
Yeah.
Line 55. So would it work to put the period after challenge and say this allows a litigant to choose?
It would.
Okay. Alan, is your hand up? Okay. Okay, then maybe we can go to lines. Well, let's just do the next sentence, which, okay. So now the portions discussing the judicial conference, lines 58, sorry, Alan? Is that where you wanted to go?
Get what do we need that new sentence that we just added there? I mean, this raises concerns that litigants can choose to bring a case in the division with, do we need that this allows a litigant to choose the division in which to file sentence? I don't feel strongly, but it just seems a little duplicative of the next sentence.
I take the point. I do wonder if it's better addressed by saying this raises concerns that litigants will choose.
Yes. Okay,
Okay.
that's a good idea. Thank you.
Then let's go to lines 58. Oh, sorry, I should give. Okay. Yes, lines 58 through 60. Let's just go sentence by sentence with this one. Are there any comments on that first sentence? Okay. The next sentence is line 60 through 68. Oh no, sorry, 64. The summary of the conference recommendation. Are there any comments? Okay. Then we'll go to line 64 through 68. Alan, you have a comment here?
Just what I think is obvious, but I think it's worth observing. It's not, it says consistent with, and I just want to say identical, not identical to.
Okay, great. Parad, before I recognize you, I do just want to note one note from our committee staff, which is that in the last meeting, we were having a conversation about whether or not ACUS has endorsed external policies before, and the consensus of the committee staff was that ACUS has not done so, and so an express endorsement would be a break from past practice, or at least a new practice. And that is the reason that this preamble text does not expressly endorse the judicial conference policy. But just wanted to make sure everybody had that background before we started this discussion. Brad, I told you I was going to come back to you, so I want to make sure I do.
Yeah, on that note, I mean, we had requested that we do something like an endorsement here. I wouldn't be wedded to doing the language of endorsement, but something in ACUS, which is sort of implicit already, that we're doing a consistent policy recommendation. But I do think we would be in favor of doing saying something here like the conference also supports or is in favor of the policy of the judicial conference would be helpful. It's a similar group to we had last time. It's a slightly different group, but the logic here is just district court judges around the country are well, I guess districts around the country are deciding whether to adopt this policy of the judicial conference, which is not mandatory. At least according to press accounts, there's different views. And while legislative recommendations are great, having ACUS saying something in support of the judicial conference, could conceivably move the needle, perhaps more likely, I don't know, than a legislative recommendation would. And then, so I guess the language I would propose is, I take your point, Kirti, that maybe endorsement is too strong, but something like, and again, not what it's particular language, the conference also supports this policy of the judicial conference. A little awkward because there's two conferences, but and then we needed, I think, discussion last time as to, and then maybe use language from the recommendations or something like as to judicial review of agency rules. It's I don't know whether that's. I like using whatever's in the recommendation. The only caveat about that is that unfortunately the judicial conference uses rule, regulation, or policy, which is probably synonymous with what we mean by agency rules, but I don't know, maybe it doesn't make a difference. But yeah, so I guess happy to take friendly or suppose unfriendly amendments to that, but that would be our proposal.
Okay, thanks, Brad. I appreciate you putting some language on the table for us to discuss. Allison, I saw your hand go up.
Yes, I wanted to speak in favor of leaving it exactly as it is in black, with the although not identical to as the only change. I think given the recommendation and after we describe what the judicial conference said, and then to say that ours is consistent, is clear that we basically like what they did. We're sort of basically endorsing it. And I think that's sufficient and gets across our point. And the other language sounds to me like it's sort of unnecessary. Like, as I said, it is implicit. And then if we're going to do that, I mean, people had concern about like reading the whole thing and what else the judicial conference might have said. And like, it requires us to put caveats, like we're supporting it as to this, but not including that. Just seems to me that it's clear from 65 to 68 that we're saying we basically like it, and that should be sufficient.
Thanks, Alan. Do other folks want to comment on the proposed addition in line 68 through 69? Okay, I think the two viewpoints have been put on the table clearly by Brad and Allison. So, Steph, go ahead.
I don't have strong feelings. I think that the formulation offered by Brad would be limited to the policy in my reading and wouldn't necessarily extend to the guidance, but I actually did want to take a moment to endorse a piece of the guidance that is not the policy of the judicial conference, but it does look like they're going to try and capture some structured data about civil actions that do try to seek nationwide relief in some form, and have encouraged folks to include that in their case captions, and I think that's really fantastic. So I definitely endorse that, although that's not quite what Brad has offered. And I think that I would also endorse the policy.
Okay. So I think if there are not further comments explaining the pros and cons of endorsement or non-endorsement, we can just move to take a vote. Option 1 for the vote will be to keep the sentence in line 68 through 69 in, and option 2 will be to delete it. And I should just say, if we keep it in, we can obviously have further debate about what it says. So option 1 is to keep the sentence in, option 2 is to delete it. So those who are in favor, committee members who are in favor of option 1, please raise your hands.
To keep it.
Ron, I wasn't sure if you said something or were voting, or
I was asking if option 1 is to keep it.
option 1 is to keep it, yes. Okay. Thank you. If we'll go now to option 2. Okay, option 2 has it. Okay. Then I think we can move on to the next paragraph. So lines 69 through 76.
Is my amendment to, although not identical to, in now?
Yes, I
Thank you.
didn't hear any objection to it, so
Thank you.
yes.
I didn't either.
All right, line 69 through 76. Okay. We'll keep going down, lines 77 through 81. Okay. Fantastic. Then we've gone through the document, and the remaining stuff is to vote on the recommendation as a whole. So option 1 will be to approve the recommendation. Option 2 will be to disapprove it, I suppose. So, will the committee members who vote to approve the recommendation please raise their hands on Zoom, in the Zoom function, I should say. And I'm going to ask Kaja to help me keep track as needed. We'll just give it one more second for votes to approve the recommendation. Okay. If we can go ahead and have those votes put their hands down. And if there are any votes to disapprove the recommendation, please vote now. Okay. Then it's approved by the committee. And with that, I want to thank the committee members for very thorough meetings to discuss the proposed recommendation. And of course, I think we need to thank Joe Mead, our consultant, for doing the work to get all of these discussions started. And I hope we will be seeing all of you at the ACUS plenary session to help explain and discuss the proposal in front of the full ACUS conference. So thank you everyone for attending today. And we'll see you at the plenary.
Yes, thanks, everyone.
Thank you.